Hi there, I'm Will Trackman. I'm the General Counsel of Mountain States Legal Foundation. Welcome to Mountain State's June webinar in our How a Neighbor or So a Neighbor Asked series. This month's webinar is called So a Neighbor Asked, How Are Threats on Free Speech Hurting Americans? We are very excited to have three fantastic guests with us today, one in-house with Mountain States, my colleague Jim Kerwin to my right. And then we have Charisse Trump and John Vecchione. I'm going to introduce them all briefly. Just a few housekeeping notes. There will be a question and answer session at the end, so go ahead and drop those questions in the Q&A box at the bottom of your screen as you think about them. And then we're excited. We're going to go about 45 minutes or so today talking about the threats to free speech throughout the United States. So with that, let me introduce first Charisse Trump, the Executive Director of Speech First. Charisse represents clients around the country in student speech matters. She is also the host of a podcast called Well Said, which is, if you're looking for a new podcast on your dial, go ahead and check that out. John Vecchione is the senior litigator at the National Civil Liberties Association, one of the fantastic liberty groups that's litigating cases out there right now, along with Mountain States and Speech First. And then Jim Kerwin is the head of our speech practice group here at Mountain States Legal Foundation. You've probably seen him quoted or featured in many of the pieces on our website. And so we're excited to talk today about how viewpoint discrimination, threats to free speech out there are really increasing and hurting Americans and making it so that we can't speak our minds and contribute to the marketplace of ideas in the same way. With that, let's jump right into it. Charisse, do you want to talk about some of the work you're doing right now and in the broadest strokes possible, some of the threats that you're seeing on the horizon to free speech in the campus context, the student context, and perhaps the professor or teacher context as well?
Yeah, so Speech First was founded in 2018, and the reason we were founded was specifically because there were a number of organizations that existed that protected civil liberties on college campuses, but we didn't see enough action on the litigation side, especially when it came to holding the bad actors accountable. We saw a lot of threats to take, to sue the universities, but we didn't see actual lawsuits amounting to large circuit and major court precedent-setting wins. So that's why we were founded in 2018. We're a young organization, but we have a lot of wins under our belt. We primarily, and I just want to clarify, we do primarily we represent students, university students, our members across the country at various universities whenever those universities violate their free speech rights. And the reason we're a membership organization is twofold. One has to do with the fact that, as a university student, you are on campus for around 4 to 6 years. And if you are trying to sue your university for violating your speech rights, ultimately, if you're a senior or a junior, the university can drag that lawsuit out. And as many of you probably know, lawsuits can go on 1 to 2 to 3 years, depending on how high you want to go with it. And what ends up happening is the university can say once a student graduated, then the lawsuit is moot, the harm's no longer being done against that student. So as a membership organization, as long as we show we have continuous membership on that campus and we're able to get students to participate in the lawsuits, then ultimately we can continue the lawsuit all the way up to the highest courts. The other reason we are a membership organization has to do with the fact that we want to protect our members' identities. A lot of students, as you know, are fear of retaliation from their universities, if they express their opinions. And so imagine a student's idea or how they're thinking about it. If they're suing their school, they still want to graduate, they still want to get good grades and have good standing on campus without fear of retaliation. So as a membership org, we can also protect the identities of our members through the lawsuits. We have seen a number of policy issues that we have sued universities on, but there's also a broad set of trends that we're just seeing kind of nationwide on campuses, which I'm happy to talk about a little later. I would say initially our lawsuits are focusing on bias response teams, which are anonymous reporting systems where students are encouraged to report on one another for incidents of bias. The university will define bias as pretty much anything they want, which is, essentially offensive speech, unwanted speech, microaggressions, not using someone's preferred pronouns. These are not exaggerations. These are literally what the universities have on the reporting forms that students can submit reports on. We've had students be told that after that when they were reported, it stopped them from actually getting promotions in a student job, for example. Someone who didn't realize they were reported because, again, they're anonymous, and not every single report leads to the student being contacted by the university. So incidents like that, where there are real consequences associated with the reports, real disciplinary action being taken. Some students have to go through mandated training programs, sensitivity training, or as we call it, re-education, as they're reported. Additionally, we've sued a lot of universities on harassment policies. So, one thing people don't realize is that universities have or do not have a set kind of a number of how many harassment or anti-discrimination policies they have to have. They have, Title IX, Title VI, those are all federally mandated. However, there's no one saying that they can't have additional policies. A lot of universities don't like Title IX and how it doesn't actually reach enough speech. So they'll write an additional harassment policy, putting it on the same page of the handbook, on the same part of the website. And oftentimes they're incredibly broad-reaching, vague definitions of harassment. Some of the examples I listed earlier as incidents of bias. Sometimes they'll are also included in what is considered harassing conduct. But even the bias incidents can also be considered harassing conduct according to some universities.
Wow. Yeah.
So you'll see it's very far-reaching. Universities find ways to use policies that already exist or new policies to get students to report on one another, to police speech, to lead to censorship and coercion on campus. Happy to elaborate on any of that. We've put out a number of reports looking at DEI mandates, freshman orientation programs, but I don't want to take up too much of the beginning time, so I'll end it off.
Well, let me turn it to John. I mean, Sharice, you mentioned that Speech First is a young organization. The New Civil Liberties Alliance is also somewhat new, but has had tremendous success just in its first decade in existence. John, tell us about NCLA, your work, and some of the trends that you're seeing.
We will. So we're about 6 years old. We were founded by Phil Hamburger, who's a professor up at Columbia, law professor. And we focus on the administrative state and often its threats to free speech. I am counsel of record in Murphy v. Missouri, which is before the Supreme Court right now, which should come out in the next 3 days. I've been sitting like a dog when he hears the key in the lock for every Thursday and Friday for June. But we're waiting for Murphy v. Missouri to come out, which is a government censorship of people on the internet by forcing or intimidating or co-opting the social media companies to take messages the government doesn't like off of those social websites. And so it's called Murphy v. Missouri because Missouri and Louisiana were the first complainants. We had a case called Changizi here at New Civil Liberties. We brought the same case, but we were dismissed in the Sixth Circuit in Ohio, and that is now, there's a petition for certiorari, and the Solicitor General has agreed that it should be held, waiting for Murphy v. Missouri, which we represent individual plaintiffs in that case. So the threats that we're seeing, and as I said, the New Civil Liberties is new, but we've had a number. It's not free speech, but we were just in the Cargill case. The Supreme Court came out on administrative. Making crimes by administrative agencies of things that are not crimes in the statute. So, but in the speech area, we're seeing we do some Title IX, which is, that was put in so that women would have access to sports and other things on campus back in the 70s, but it has metastasized into a general, let's get out the people we don't like statute in a lot of ways. And sometimes, not always. Oftentimes it's for sexual assault or something like that, and there's due process problems with that. But the speech problem is this idea of what offends people or is harassing on campus. If you're loud and well connected on the campus, you seem to get a Title IX complaint through, and if you could be, I mean, we just saw with all the stuff that was happening to people who were Zionists, which turned out to be anyone who was Jewish on these campuses, their offense didn't matter. So one of the threats to free speech we see on campuses, I think, is just not equal treatment of equal activities and equal speech. I think that is the new frontier, because it does seem that who you are by your viewpoint is whose ox gets gored on campus, which is a little different from saying we're going to say this this speech is no good. What they're saying is, we don't like this type of speech, or shouting at people and all that, but we're only going to punish the people who are shouting whose views we don't like. So you see some of that. In our area, we see government doing this through the social media companies. The social media has now taken it. Well, look, we're on Zoom, right? That people are online, they're looking out, and they think it used to be 20 years ago, the motto was information wants to be free. Well, information may still want to be free, but the government doesn't want information to be free. It wants information to be, tamped down. And the social media companies, because they are regulated entities and they want things from the government, they can be intimidated because the government could say, we're going to take away your 230 protections. And the government in our case said, well, that takes Congress. Nobody can do that alone. But, well, if you control the Justice Department and the FTC and all of these legal, you have the world's biggest law firm, you can put in a lot of briefs that Section 230 is very narrow or it's very wide. You don't need Congress to do anything like that. And that's billions of dollars that they can threaten to do to you. They can bring cases, all kinds of things. And they can also just say, you're not going to be in good with the government. And, you're in an industry where everybody likes the government when one party's in, and they don't like it when another party's in. So there's a lot of ways of doing it. And in Murphy, we saw the whole panoply of new government censorship. We saw intimidation. We saw threats. We saw cajoling. We saw we're all in this together. Opposite views are views that aren't like this, are just bad people have those views. You don't want to be like them, that kind of thing. And this was all in emails. So we find that this is a more insidious way of going about censorship. They don't even ask Congress to pass a law. They use the administration and people in the administration to use back channels. One of the things the government argues all the time is that they have the bully pulpit, right? The president has the bully pulpit. He can yell at whoever he wants. He is, as an individual, he has free speech rights, but also as the president, he's allowed to talk to the nation. And well, if the bully pulpit's there, you wouldn't be doing it in secret. You wouldn't have Mike Larry. You wouldn't call up, somebody over at Twitter or Facebook and say, we really don't like this Hunter Biden laptop or this vaccine talk. Or one of the things that most angers me, and I think, you're allowed to say false things and lie and say all kinds of things. That's what the First Amendment actually says. The government can't go around deciding what's true. But one of the advantages we have is we have clients who were saying true things and the government was saying false things. So the government was actually silencing Jay Bhattacharya. You might have seen him, but he and Martin Kulldorff was one of the most widely cited epidemiologists in the world before COVID. And when he came out and said, this is how you approach respiratory viruses, you don't do lockdowns, you don't do this. This is how we've traditionally done it. And we think you should do it this way, and there'll be less damage to education and all that. He was absolutely right. And they said, get that out of here. That's not our message, So I do think that the new censorship will be by the government calling people up and sending them emails and having vague threats, while the president and his spokespeople say the people who have these messages are really bad. And besides the scenes, they're saying you're the bad guys.
Yeah. Well, thank you. That's a great outline. Jim, let's turn it over to you. I mean, some of the themes we've heard so far are about education, social media. Where else are free speech threats emerging? I mean, it's all government, right? Because the First Amendment only applies to the government. But where else are we seeing threats to free speech emerge? And are John and Charisse, are their viewpoints in line with yours about viewpoint discrimination and how sometimes there's free speech for some, but not free speech for all?
Well, thanks for that question. And it's a pleasure to be with such distinguished company. I would say in response to the first question, a big problem that's sort of at a different level than what we've talked about at universities and the federal government, response to big social issues, has to do with kind of institutional capture on a more granular scale of many government institutions. So it could happen anywhere that, for example, let's say a state level agency Like we have a case with a public employee in the state of Oregon, and she works for a state level agency that has a job to do. It's there to protect the environment in the state of Oregon. But that institution has unfortunately been captured by activists, right? Who want to do something that they probably know is illegal and certainly questionable. And the free speech aspect comes in when they take very strong measures to try to prevent employees from getting the word out, about what might be going wrong, what illegal conduct might be being engaged in at the level of this government agency. So that's a very serious threat to Americans' free speech, not only for the free speech interests of a particular employee who might want to blow the whistle or raise questions about whether what their government employer is doing is legal, but also to the rest of us. Like, we rely on the knowledge of insiders to know what's going on sometimes in government agencies. And there's also, I think, an interesting aspect. The question posed was, how are attacks on free speech hurting Americans? One kind of subtle way that when government censors speech, at least in certain contexts, that it has negative effects on Americans has to do with the problem of self-censorship and what might be called false consensus. And I think Charisse touched on this a little bit when she was talking about the problem of bias response teams at university and how that might have a chilling effect on students, right? They might decide that they've seen somebody get raked over the coals and brought through a disciplinary proceeding for saying something, and they're thinking, I don't want to be like that guy. I don't want to get dismissed from school. And so I might go to speech first so I can remain anonymous. They might take another tack, but it's a very important aspect of this that there's sort of when the government censors people's speech, it often has a multiplier effect in that once you've seen an example made of somebody who speaks up, then you are much less likely to speak up yourself. And if that keeps happening, then you get this false feeling that there's a consensus that everybody actually agrees with, for example, very aggressive DEI in the government agency, which is the issue in our case in Oregon. Or, another type of situation might be a doctor in a gender clinic who has legitimate questions about the care that's being given to minors who have confusion about their gender. You can debate these issues. There are reasonable views on all kinds of different sides. The problem is when the institutional administrators have been captured, they don't want people talking and raising questions about what they're doing, and they bring the hammer down on somebody who blows the whistle, and then that has this knock-on effect for other people who are then, not me. So that's a long-winded way of saying, what can we do to push back? It's bring lawsuits, which is what we're all doing. Because you've got to change the incentive structure for the government actors. They've got to know if they're thinking about disciplining somebody because they've questioned what they're doing, they've got to think twice, 3 times, 4 times about that. Not the way that the law is currently, unfortunately, I don't know how deeply we want to get into the weeds, but there's a legal doctrine called qualified immunity that basically gives government actors some comfort that if they make a mistake and end up violating somebody's free speech rights, they're probably going to get off the hook. They'll get a second bite at the apple because they can always claim that the law wasn't clearly established. They didn't know what they were doing was wrong, even though ignorance of the law is no excuse in most other contexts.
I'll just add that you get an injunction, but you can't get money from them.
Yes, that's right. I think, unfortunately, with the injunctive relief piece, my sense is that, maybe in the past, government actors were of a different sort of professional cast or feeling about things. And they really would, if a court said, I'm going to issue an injunction to prevent you from doing something, or even a declaration that you violated somebody's rights, they'd really take that seriously and they'd stop doing it. I don't know. In today's day and age with the capture by activists of a lot of these government institutions, I'm not sure that they care about that. Like the thing that might really, and this is a long slog, the thing that might really get them to think twice and 3 times about whether they're going to violate somebody's free speech rights isn't the injunction, because they're going to be gone after a few years, and like they might just keep doing this, whatever they're doing anyway.
Well, all of
I
our,
need to be
just one
done.
point on that, all of our lawsuits are injunctive and in injunctive relief, but ultimately we do come to a settlement agreement then before we end up even having to argue the merits. Usually we can win PI on standing, and then our settlement is binding for them, and our settlement would often include eliminating the policy, rewriting a policy to include free speech protections, as well as, you know, attorney's fees oftentimes. So
Wow,
You know,
wow.
there is some consequence there.
And on qualified immunity, I totally agree with you, but I didn't want anyone out there to get the idea that they can't call us and sue even if they can't get money.
Sure.
Well, let's talk about some of the, favored viewpoints out there in terms of what is and is not being suppressed. Sharice, you mentioned DEI as did you, Jim. Why is DEI this monolith right now, and what is preventing students or anyone really from criticizing it or feeling like they have the freedom to, contribute criticism or skepticism about DEI?
Well, a lot of the reason there's hesitancy to criticize it publicly. I think DEI, we've been pretty successful in labeling it as something that is not good. But for those who are still afraid to apply that label, it has a lot to do with the fact that it's like, well, diversity sounds like a good idea, right? Equity, inclusiveness. We want to have those sentiments on college campuses. But what those individuals are failing to realize is just how systematic and just how insidious these departments are. And even if you eliminate the department, which I applaud a lot of the states who have defunded these departments and rid the campuses of the administrators, oftentimes you'll still see that this thing has existed, this ideological kind of juggernaut has existed on college campuses for long enough, for decades now, to the point where it has really built itself into the curriculum. It has built itself into faculty departments, academic departments. And in our research, we found that you wonder why students, we were wondering this too. We're like, why are students using these things called bias reporting systems? Why are students so quick to file anonymous reports on one another when they're just offended? Some of the reports we've seen, the students don't even remember what the person said that offended them. They just say that that person said something offensive, and it's still filed away and kept a record on, and administrators still investigate it. So we wonder why students are thinking that way. It's because right when they step on campus, the first thing that happens is the freshman orientation program, which we found a couple years ago. We asked for all the major universities, all the public major universities, information through an information request on their freshman orientation materials. We found that 91% of the materials focus on DEI themes. And by DEI theme, I mean teaching students about microaggressions. If you go around asking students what microaggressions are, most of them don't really fully understand what they are. There's no real clear definition. In fact, they'll tell you that you don't know it until you hear it. And that's what the universities define it as well. Some universities provide information on microaggressions, such as it's as simple as asking someone where they're from or why they're why they're studying a particular topic. So if you're wondering why students are walking on eggshells, there's already a large sentiment of self-censorship and coercion that's taking place because they're being beat over the head with this. By the time they get to campus, K through 12 is already completely drenched with all of this rhetoric. So when they get to campus, they're pretty numb to it. And then orientation programs say, here are all the reporting mechanisms available to you. Here are all the counseling services available to you to talk, if there's anything that goes against what essentially is kind of like this orthodoxy, dogma of what people like to say woke ideology. But when we're really saying woke ideology, which is what essentially this DEI sentiment is, it's DEI is essentially kind of way to put it is CRT or critical theory in practice. So if you were to take anything from like critical race theory, critical gender theory, and you were to implement it into a bureaucracy and to actually practice it and enforce it, DEI would be the result. The DEI departments would be the result of that. And so that's essentially what we're seeing here. They're enforcing policies to reinforce a very particular ideology, which has Marxist roots, and we can go down that path if you want. I don't want to go too far down that path on woke ideology, but happy to elaborate on it for those who are listening. But that's ultimately what we're seeing here. And I will say on that freshman orientation report, we found that 91% of the materials were DEI focused themes. So I said microaggressions, trigger warnings, anti-racism, anti-American rhetoric is also what we counted. We were looking for phrases that met all of these qualifiers: critical race theory, critical gender theory, all of this. including implicit bias tests, which I can talk more about, various things that make students feel like they are inherently racist or that there's something wrong with them. Anything to create division and enmity amongst students so that they look around and they see each other through a lens of someone that they might need to report, or someone that they might need to monitor or be careful around, rather than give them a sense of fellowship. We also found in that same report that only 30% of the universities we looked at even mentioned free speech or viewpoint diversity in their orientation materials once. And it was still a seven.
As you're looking at it.
Yeah. Exactly. In that 30%, it was still a 7-to-1 ratio of DEI topics to free speech, viewpoint diversity topics. So
Wow.
Again, if you're wondering like where this sentiment's coming from, it starts there, or it actually starts in K through 12 when you really think about it, and then it kind of builds on it when they get to college. And then they have all these reporting systems available to them. We found that 56% of the universities, we looked at over 800 schools across the country, public and private, 56% have what is a bias reporting system or a bias response team of some sort on campus. What happens on campus doesn't stay on campus. New York City has a bias response team. Portland has one. I think Michigan was trying to implement one at one point. So, well, you're going to see more of this kind of anonymous reporting mechanisms, something straight out of George Orwell's books. It sounds eerie to you, it's because it is. It's nothing new under the sun. We've seen these types of practices before in totalitarian regimes. It's again been practiced before. But not to get to too fine a point on it, I think you mentioned something earlier, Jim, with the institutional capture. You mentioned questioning, and that's ultimately what you're trying to do here, right? It's like when you're trying to implement a new ideology, when you're trying to change someone's reality or alter someone's reality, you have to get rid of the dissenters, you have to shut down dissent, you have to eliminate questioning. And that is directly linked to speech, obviously. So you can't speak up, you can't push back. You should, keep your head down and just do what you're told. Don't participate in conversations. We've seen trends across the country where faculty don't hold class discussions anymore. They just lecture and leave because they are afraid of being reported for creating an unsafe environment for students. We've seen just complete dialogue fatigue across the board where students do not engage with each other. Most of them, from what I can tell, when I visit campuses and ask for, an in-room survey, most of them have not even seen a formal debate. They have not even witnessed what a formal debate looks like on political issues. So they just have no exposure to what dialogue is supposed to look like on political issues. And then they're being beat over the head constantly with this, DEI rhetoric. And the DEI report that I mentioned earlier, I'll just end on this. By the way, we looked at schools across the country to see how many of them mandated DEI courses. So imagine you go through your training programs at the beginning of your 4 years. Then you have to take, we found that 67% of the schools across the country, and we looked at, I think it was almost 250 schools, private and public. We found 67% mandate a DEI themed course for students to graduate. Oops, I think I froze, sorry.
Yeah.
They mandate a DEI themed course in order for students to graduate. So that means that for gen ed requirements, students have to take a DEI themed course, and that was 67%.
I mean, it's frightening. John, let me switch gears a little bit. I mean, you've mentioned your case right now that you'll get a decision on very quickly. First, let me take a step back and congratulate NCLA on the Cargill decision, which is a tremendous victory for not just the Second Amendment, obviously, because it's not a Second Amendment case, but the beat back of the administrative state in the context of bump stocks. But given your experience in Murphy, do you sense that courts are getting that there is a threat to speech out there, that there's a press for orthodoxy?
Well, I'll give you, first, VULO has come out, right? So we put an amicus brief in VULO, and that's the case where you had, I think that it was a 9-0 decision. There, the administrator of the insurance companies in New York called them up and said that there was tremendous risk if they did business with the NRA. And in that case, the NRA had actually issued insurance policies that were against New York law because they tended to insulate someone from bad actions rather than just accident. So they admitted that. But what she was really doing, what was really going on there, is she didn't like the NRA. So she was trying to get everybody not to deal with them because of their speech, because of what they said. The Supreme Court is very sensitive to this. And what we do see is, I think that there's a fear of free speech now growing up that over the last, since I was in college, right? I remember I blew off our initiation. It was some kind of care, touchy-feely lefty thing when I went to school, but we could just blow it off, and I blew it off, and I didn't go, and maybe that's why I'm here now. But the real reason is that but no one took it seriously. And then there was an attempt on campuses to get rid of Western civilization, right? Western civ courses and all this. And we thought we'd beaten that back too, but we went away and they kept going. And so what you have is young people who are, my own boys have said, you see pictures of them behind me, but they have said in high school that, they didn't want to speak out in high school in Fairfax, Virginia, because it was, they thought they'd get in trouble. Or at least attacked. And there's this sort of anti-free speech and fear of debate resonance in the culture. Well, you're allowed, culture develops how it develops, but we have to try and wall off the state from that. And one case we haven't brought up is net choice. And net choice is Florida and Texas passed laws because they felt that these large companies, I think they called them monopolies, but I'm not sure, were keeping off conservative views. Well, we didn't put in any amicus briefs. Some of our friends were on one side and some of our friends were on the other side, and we were with our friends. And I think that is what do you do when all the private companies have one view? One thing that we see is that the government is able to make companies have one view. If the government is making companies have one view, and sort of getting around all the antitrust laws by having the government coordinate where nobody else could, right? They'd all be in trouble with Lena Khan if they were doing it on their own. When the government's having them do it, oh, that's fine. That's just us all working together. So that's another threat to free speech, that the government can actually coordinate amongst companies and then punish the outlier, the company that doesn't go along. Elon Musk, right? How many attacks on him are legitimate from the government? And I'm sure there are some. And how many are, hey, I'm looking at Elon Musk because he's not with the program. So you do have that. I will say one other thing. From the left, I have heard from many, from some Palestinian and Arab students that they do feel on some of their campuses they can't criticize Israel. That's not what we see on our YouTube, but I don't doubt that could happen on some campuses. And I don't mean shouting and all the rest of it, but they don't feel they can even say, I'm for against this policy or that policy. So it can happen, I suppose, from a non-right perspective on some issue. But it's the only one I can think of right now. I can't think of another one that might be a leftist view that isn't allowed on campuses, and even that the government tries to tamp down. I don't know any, although except I will say this. Resistance to vaccines and raw milk, when I was growing up, were all lefty things. They were Malibu and hippies who were still out on the farm in upstate New York and never left Woodstock and all that. And now there's suddenly right-wing views, and I don't know how that happened or when it happened, but now that's it.
Well, Jim, let me turn over to you. Before I do that, let me remind everyone that we're about to take questions. I see that we have some questions piling up in the Q&A box there. If you have one, we'll get to them in a minute. Go ahead and drop it in there. Jim, you've heard a lot about the discussion from John and Charisse. What are you looking for on the horizon? Obviously the court's going to come down with Murthy. We've got some cases at Mountain States. Where do you think the breakpoints, or I guess the watershed cases, may be out here to change, to get back to a place where we do have a marketplace of ideas, where the culture does take a different turn in order to avoid some of the threats that we're seeing?
Well, I mean, there's a lot of cases percolating up to the courts at the moment, including some that we have. I think that, Charisse put a finger on a really important issue. Is the K through 12 schools. That yes, there certainly are a lot of things going on at university where, a student who does come in with maybe an open mind about free speech is going to be quickly disabused of that idea. But many students aren't coming in with a neutral view on free speech because they've been in the K through 12 system. As John's mentioning, like if you're talking about private schools, which is a small fraction of students, like it or not like it, they don't have a First Amendment duty to avoid suppressing student speech. They can do what they like, but public schools definitely do have a First Amendment duty. And we have, I think, a pretty important case. That's a K through 12 case on behalf of a student named Jaden Rodriguez, who was prevented from wearing a patch on his backpack with an image of the Gadsden flag, the "Don't Tread on Me" flag from the Revolutionary War, which might seem like kind of, the school said you can't wear that because it's got roots in slavery, was the excuse given by the school. This might seem like kind of a local sort of trivial, maybe, it was viral video, so it's kind of salacious, but it actually points to a lot of the themes that we've been talking about already. Because if you think about the reasoning the school gave, there's one question: did that violate the Constitution? The answer, we think, is clearly yes, because there's a well-established First Amendment standard for when schools can suppress student speech. But lurking underneath that, I think, is an even more important issue. Why did they do this? They did it because they're seeking to advance an agenda that we've been talking about, this agenda that erases U.S. history, right? That says anything kind of associated with the founding is suspect and might in fact be racist and evil. That's not technically a free speech issue. It doesn't matter why the government violates the First Amendment, but it is really important. This context is it's feeding into a lot of these bigger issues. So we think that's a very important case. We've talked about some of our others. But yeah, hopefully, I think that answered your question. Yeah.
That brings something up. I will say this: the original free speech cases out of the 60s were mainly, like, some of them were communists, some of them were all kinds of people. And the ACLU did all those cases where it was perceived as the establishment, the conservative establishment, although I think it was the old New Dealers myself. But in any event, all those free speeches that came out, and everyone was so fond of them at the New York Times and the Washington Post, were all used in the Voodoo case. And who popped up, much to my surprise and delight, with the ACLU represented the NRA like the old days, because they said, well, we were counsel on all those cases that we got to be for the cases that made us famous. So we're still for the cases that made us famous. And I did like to see that. And maybe that is just a little straw in the wind about maybe where things are going.
Yeah, absolutely. Well, let's turn to the questions. We have a couple minutes. If you have a question, drop it in the box. I'm going to start with the first question, but I can already see the third question starts with "Amen, Charisse." So that's a good note for Charisse, your comments so far. So the first question is about, I think, open meetings issues. So we've talked about campus issues, social media issues, and public employees, but we haven't talked about the citizens' right to maybe engage in public comment and, I suppose, irritate their public officials face to face. And I think I've seen some videos where individuals have come to talk at public meetings and they've been gavelled down so that they can't speak their mind, or they've been ushered out of the meeting. There was some famous incident just in your folks' neck of the woods in Virginia where a father came to talk about his daughter.
He was arrested.
What?
Yeah.
He was arrested. He was prosecuted.
Yeah.
He had to be. I think the governor had to pardon him. They sued. So what happened there was his daughter had been raped in a bathroom there, and he was trying to get this out, and they were trying to cover it up, and everyone went berserk there it was in Loudoun County, and he was just shut up and arrested and thrown out. Now, he might have been over agitated, but there was a time when if something like that happened and if someone got upset at a public meeting, there would not have created a criminal case that the governor had to get involved in. But that is happening. And the other thing that's happening at public meetings of schools is that they put these books with pornographic statements in them, which I suppose some our libertarian friends would say is free speech, but it's a public library for children. And the parent gets upset, and now I'm going to read from the book. And they say, you can't read that at a public meeting. It's just not allowed. So it's almost like the same people who want the pornographic book in the children's library won't let you read it at their public meeting, which is bad, but it's also hilarious in a way. And it shows what you were just saying a minute ago, that this is some kind of war to get rid of certain thought and keep in other thought. The traditional thought goes out the window, and then there's this effort to create a new people by having strange things in front of the kids. So that is so you could probably sue. Someone would probably sue where the one side says it's book banning to just not have every book in the world in your school library, and then the other side says, oh, we should be able to talk about what books are in our library. No, you can't do that. So it's really shows the dichotomy.
Sure.
Yeah, on that, just yeah, not so much on the county official question, just because we do primarily represent university student members against their universities, and oftentimes our lawsuits are going to be against public universities, obviously because they're state actors. Just to clarify all of that up front. But I'll just tack on, because what John just said reminded me of something. You know, I think we have a tendency, especially on the right or the more conservatives or libertarian side, to actually think that the far left cares about logic and reason, when there is a clear connection between a legal argument that contradicts what they're saying. And you're like, wait a second, you guys argued this last time, now you're arguing this. I think it's just really important, from just the reality of what I understand. They actually don't care about logic or reality. Their goal is to change our reality. Their goal is to change how we see things. So they don't need a logic for that. They don't need to understand how reality works for that, because all they want to do is just win. And if they have to contradict what they said 2 weeks ago in order to win, they will do it, because this is a group of individuals who believes that the ends justify the means. So, and you'll see it in all of their signs, at all of their protests. They say by any means necessary. They said that during the riots in 2020. They said that during the encampments, just recently, the pro-Gaza encampments, they had signs that said all of that. So I think it's just us understanding that how they are thinking about all of this.
I have a question. Out there in Colorado, you have a guy who wants to bake one cake or another cake. Who says, and your administrative agency keeps going after him. If he said, I just won't make chocolate cakes, I think he'd be okay. But the Supreme Court has said something about viewpoints discrimination there. What do you think of that type? We don't do that sort of thing usually, unless a federal agency has been there. But it does strike me that it is part of this problem that you get punished by what's supposed to be a neutral law just because you're taking the wrong view.
Jim, go ahead.
Well, yeah.
I think that's absolutely correct. So that case is actually at the Colorado Supreme Court at the moment. And we filed an amicus brief in support of the cake maker there. But yeah, I mean, the Colorado administrative agency just keeps coming after this guy, and it's explicitly activist run. The person who's making these complaints is a lawyer and an activist, and I mean, it's very clear in this particular case, they tried to find a way around the Supreme Court's decision in the wedding website case, whose name
303 Creative.
303 Creative.
Yeah, 303 Creative. Yeah.
Right. To try to, just to find kind of a technical angle to say, all right, well, I understand now that I can't compel a business to create a work of a creative work like a website, that celebrates something they don't believe in that case, same-sex marriage. So I'm going to try to find a way around this and get you to bake me a cake that's blue on the inside and pink on the outside, or vice versa. I can't remember which. And I'm going to ask you whether you'll bake that cake, and only after you say yes, I'm going to reveal to you, well, actually, in the particular circumstances of my life, I believe this cake represents a gender transition, which they know will be offensive to the cake maker. So, I mean, this is viewpoint discrimination in a sense. It's really just an attempt by the Colorado agency here to really just say, if you don't agree with us in our very forward thinking, according to them, view of transgenderism, then you really shouldn't do business in the state of Colorado. You should get out, bigot. So that's, this fits the general theme. It's a problem, and I do believe it's part of the bigger problem of institutional capture. I do, by the way, John, I just want to say I completely agree with you. Like, this is all contingent. 40 years ago, the free speech cases were all coming from the left, because the institutions were in their, they weren't captured by left wingers. So, their speech was being suppressed, and, maybe they were right sometimes. And I think these principles are timeless, and they should be applied anytime. And I'm really glad to hear that the ACLU, which unfortunately in many cases seems to have not taken that lesson to heart and is saying, well, while we used to believe in the principle of free speech, we're really going to start taking the other side in these cases where the institution now kind of agrees with our political point of view rather than the principle. But I'm glad to hear that in the Vulo case that they stuck to their principles at least one time.
Yeah, I'm going to combine all the rest of the questions and then some of the themes we've talked about here, and maybe invite all of you to remark on this as some of our closing thoughts. A lot of the questions get to this point of ideology and how this is ideology of suppression. And if I could comment on that, maybe something like, it's wrong to offend me. It's your burden to stop offending me. And is that motivating these attacks? And are those, as the topic of our webinar is that how are threats to free speech hurting Americans? Is that ideology seeping into our culture that you have to stop offending people? The only way to do that is to stop speaking. And if you don't mind, Jim, I'll start with you in terms of that and how to confront that to go and moving forward.
Yeah, well, you might think that's true. I'm not sure it is because it depends on who's saying they're offended, right? If to not be too blunt about it, if you are at the top of the food chain from on the intersectional ladder, or really at the bottom, if you have quote unquote all the privilege, if you're a white male heterosexual, you're free. We can offend you all we want. There's not going to be any problem there. It's so the general theme of I think that the offense has just become weaponized. It's not so much that we care about offending people as a society and we would like people to stop offending them, and we're going to use the government to. It's a very particular kind of offense. And I think it's, really just used as a weapon to advance broader social agendas, unfortunately.
John?
Well, there are some people who I always think of Big Bang. Sheldon Cooper had his podcast, Fun with Flags, right? And virtually no one is watching that. And there are a lot of people who say, I'm being suppressed because no one, because I don't have a big audience, right? And you see this a lot where people say, I'm being suppressed because of this, when it's just because they have a niche thing and no one's interested in it. But what we really see, I think, is that some people use I'm offended to get eyeballs and to draw attention to themselves. And then the other thing about it is, and then they want to shut out the other view of the other side that's offended by them. I do think, but again, I'm seeing little hope. In the last year and a half, I'm seeing little hopeful signs that people are like, okay, I'm worn out of offense. Now, people are still trying to use it, but I don't see it as successful as it was 4 years ago. I think you're seeing a little pushback both in the culture and in the law. And it's this little mustard seed that I'm grasping onto as I see little things here and there that I hope expand, because there are really offensive things that the society could say, I'm not going to support that with my dollars. But whether or not you can say I'm offended and then get something banned by the government is a completely different issue. And that's what we have to stop, because the government knows it can't pass a law to do it, but it's got all these other methods, and we've got to be using the law to push back on those other methods, as we also push back on, are you really offended by that? Come on.
Charisse?
Yeah, I think as as most of the folks on this call know, the Supreme Court has ruled time and time again, even as recently affirming in 2019, that there's no offensive speech or hate speech exception to the First Amendment. And the reason for that has a lot to do with this concept of discriminatory enforcement. Who gets to define hate? Who gets to define what's offensive? It's incredibly subjective and overbroad, as we've seen in the additional policies that a lot of institutions have tried to implement. However, what's actually kind of interesting about this is there is a weird kind of mixture of sentiments here. You have, on one hand, the kind of the coddling of the American mind sentiment, right? Where you have incredibly hypersensitive, hyper anxious generations that are being exposed to things that they just fundamentally cannot handle. And that could be as much as something as small as just a controversial conversation, a political position. And they just don't know how to engage with it. And it has a lot to do, I think, with social media and how they're raised and how they're trained through the education system to think about opposing ideas. What is interesting on this note is there was a Gallup poll a couple of years ago, and I was talking to some college students about this, kind of trying to get their take on it. there was a Gallup poll that said Gen Z which is currently in college right now, but they were in college as well a couple years ago during this time. They were the largest percentage of all generations before them. They had the largest percentage of registered independents at that age than any other generation before them, and the largest percentage of self-identifying moderates. And I asked them, is this just like fatigue of like not wanting to engage with either party because you hate both parties, or is it something deeper? And most of them said that it was something much deeper. In fact, it had more to do with wanting to seem open-minded and not wanting to engage in controversial, or not wanting to take a controversial position on something. And so when I challenged them on that and said, well, taking a position is the first step to developing your convictions. And all that does is tell me that you guys are all just afraid to take a stand on an issue. And they actually acknowledged it. They said, no, there is a serious issue with apathy and complacency in our generation. And they'll admit that a lot of students won't take a position because they're afraid to. They're afraid to say what their thoughts are out loud. And this comes back to what we were speaking earlier about over the years of just how they were raised. Keep in mind, this generation especially, their entire life has been social media present, has been DEI language heavy, right? All throughout their education. This has been unless they're homeschooled by conservative parents who don't agree with this stuff, they are getting this one way or another. Private schools are not necessarily a guarantee, and neither are charter schools. So by the time they get to college, they're so beaten down by it all that it all just seems very normal to them. So on the offensive speech stuff, yeah, it's a combination of they don't want to rock the boat. They don't see a huge payout in taking a stand. They don't see that as like a reason to take that risk. In fact, the risk, and some argue with me that, look, why don't they just suck it up and the college students should just be more brave and courageous? And I'm like, look, the risks are actually much higher than they were 15 years ago, 20 years ago on campus, because everything you say is being recorded. I think it's important to recognize that these students are currently operating in a surveillance state. Every single thing that they say or do can be recorded, can be posted online for the entire public to have a record of what their thoughts are forever. We didn't have to grow up with that. That's kind of terrifying to think about. So this is their calculus. Any future employer can Google them and see if they were ever accused of being a racist or a bigot, or if they have drama associated with them. So again, these students are operating in a very different environment. I think it's just, there's a lot to say here. I don't want to go over time. I know I keep ranting on about these things, but there's just a lot for us to understand about how they're thinking about it.
And I'll just say about that, it's not just the phones, it's no unsupervised play. None of these kids have ever gone out on the street and formed a baseball team with all kinds of people who are shouting things at each other. They've always gone to travel camp or whatever the heck it is. So I do think that it's not just the phones, it's that they're always under somebody's adult supervision. As I can tell, I don't see anyone under the age of 10 outside ever by themselves.
Well, as terrifying as all that is, I'll take some comfort in John's mustard seed about the hope that things are going to change. Thank you so much, John, Charisse, Jim. We are honored to have you here for this month's webinar. We are actually, this was one of the most robust conversations we've had of late, especially on a topic of such importance. So thank you all, and thank you to our people who submitted questions. Very, very good topics to discuss. And stay tuned. There will be a July webinar. We'll be talking about all of the SCOTUS decisions that have been handed down this term, including some of the cases that John was talking about that have been litigated by NCLA. And we're very excited for that. So keep an eye on your email for an invitation to that webinar. And we look forward to talking to John and Charisse again at a future time on the same or other subjects. Thank you once again. And with that, we are adjourned.